Okay, I have a chart here about taking versus regulation. Oh, I've read that already. Then I read about the building development dedication requirements, and I was like really lost but I think I might have read it twice. These elements are in a paragraph form, so that's why I think I got thrown. Municipalities often attempt to condition or development permits on a landowner's Romanet 1, conveying title to all or part of the property to the government, or Romanet 2, granting the public an easement to access the property, known as exactions. These conditions constitute a taking unless the government can show there is an essential nexus between the condition and the proposed development. For example, the condition relates to a legitimate government interest. And Romanet 2, there's a couple, the Romanets are not in order. The adverse impact of the proposed development is roughly proportional to the loss caused to the property owner from the forced transfer. Moreover, the Supreme Court has found a taking not only where land was in fact dedicated in contravention of the above requirements, but also where the landowner was denied a permit for refusing to dedicate land under a government request that was in contravention of the above requirements. So that's like a crazy paragraph. Building development permit dedication requirements. They're pretty heavy. If you got this case came across your desk, have fun arguing that. Remedy. So this is remedy inverse condemnation is number 3. I know I read this as well as just compensation and worthless property within the takings versus condemnation. Is that what that's called? Oh, sorry, takings versus regulation part of the section about the takings clause. So inverse condemnation. When the government acts under the power of eminent domain to take property for public use, it will condemn the property and pay the owner just compensation, i.e. the fair market value of the property taken. When property is taken by occupation or regulation without condemnation proceedings, the landowner can bring an action for inverse condemnation. If the court determines that the government action amounted to a taking, the government will be required to either pay the property owner just compensation for the property or terminate the regulation and pay the owner for damages that occurred while the regulation was in effect. For example, temporary taking damages. Just compensation usually is measured by the fair market value of the property taken at the time of the taking. The measure is based on the loss to the owner. Increases in value to the owner's remaining property as the result of the taking are not considered. Worthless property. Just compensation is measured by the loss to the owner, not by the gain to the taker. Thus, while property that is worthless to the owner can be subject to a taking, no compensation will need be paid when it is taken. Now we're moving to Section 16, Introduction to Substantive Due Process and Equal Protection. A. Relationship between substantive due process and equal protection. Both substantive due process and equal protection guarantees require the court to review the substance of a law rather than the procedures employed. So, if you don't understand this critical distinction, there's no point in going further. So, substantive due process and equal protection. Here's how they're distinct. Both substantive due process and equal protection guarantees require the court to review the substance of a law rather than the procedures employed. For substantive due process, if the law limits liberty of all persons to engage in some activity on the NBE, it usually is a due process question. That's a substantive due process question. If the law limits all persons from engaging in an activity. Equal protection, however, is the opposite. This is how it's different. Is the law treats a person or class of persons differently from others. On the NBE, it is usually an equal protection problem. Class of one. The Supreme Court has recognized, at least in relation to property regulation, that an equal protection claim may be brought not only for discrimination against a group, but also for arbitrary treatment against an individual, a class of one. However, the court has held that an at-will government employee who claims to be a victim of arbitrary discrimination cannot use the class of one theory to make equal protection claim. Right. Part B, what standard of review will the court apply? Under either guarantee, the court is reviewing the legitimacy of governmental acts. 3 standards of review are used: strict scrutiny, maximum scrutiny, regulations affecting fundamental rights, for example, interstate travel, privacy, voting, and First Amendment rights, or involving suspect classifications, for example, race, national origin, and alienage, are reviewed under the strict scrutiny standard. The law is upheld if it is necessary to achieve a compelling government purpose. This is a difficult test to meet, and so a law examined under a strict scrutiny standard will often be invalidated, especially if there is a less burdensome alternative to achieve the government's goal. So this applies to fundamental rights, suspect classifications involving race, national origin, and alienage. Exam tip: the language used to describe strict scrutiny sometimes varies. For bar exam purposes, narrowly tailored to achieve an overriding government purpose and necessary to achieve a compelling government purpose mean the same thing. Burden of proof: the government has the burden of proof. Intermediate scrutiny: regulations involving quasi-suspect classifications, i.e. gender and legitimacy, are reviewed under the intermediate scrutiny standard. The law is upheld if it is substantially related to an important government purpose. Burden of proof: it is unclear who has the burden of proof. It is probably the government. An intermediate strict scrutiny? So these is applied to regulations involving quasi-subject classifications. For example, gender and legitimacy are reviewed under the intermediate scrutiny standard. The law is upheld if substantially related to an important government purpose. Rational basis is the minimal scrutiny applied to regulations that do not affect fundamental rights or involve suspect or quasi-suspect classifications. Most laws, in fact, fall into this category and are reviewed under the rational basis standard. The law is upheld if it is rationally related to a legitimate government purpose. This is a very easy standard to meet, therefore the law is usually valid unless it is arbitrary or irrational. Burden of proof: the person challenging the law has the burden of proof. Classifications that are not suspect or quasi-suspect. The rational basis standard is used to review regulations involving classifications that are not suspect or quasi-suspect, such as age, disability, and poverty. Exam tip: many exam questions ask you about the standard that the court will use to review governmental regulation. Therefore, you need to know which standard will apply in a particular case. Example: if a fundamental right is involved, strict scrutiny is applied. However, the choices may not name the standard strict scrutiny, but merely state it upheld if, quoting, upheld if necessary to a compelling government interest, end quote. Be prepared to recognize the standard by name or definition. Exam tip: due process or equal protection questions also commonly test your knowledge of which party bears the burden of proof. Know the standards and their respective burdens. Substantive due process, section 17. Constitutional source, 2 clauses. The due process clause of the Fifth Amendment applies to the federal government. The due process clause of the 14th Amendment applies to state and local governments. The same tests are applied under each clause. Applicable standards: when a fundamental right is limited, the law or action is evaluated under the strict scrutiny standard. In all other cases, the rational basis is applied. So we've transition quite quickly into substantive due process after those exam tips. The two clauses are the Fifth Amendment Due Process Clause, the 14th Amendment Due Process Clause. So they apply respectively to the federal and the state and local governments. The same tests are applied, though, under each. And what is that? When a fundamental right is limited, the law or action is evaluated under the strict scrutiny standard. In all other cases, the rational basis standard is applied. A few rebuttable presumptions may be invalid. If facts are presumed against a person so that she cannot demonstrate that she is qualified for some important benefit or right, the irrefutable presumption may be unconstitutional. Exam tip. Supreme Court no longer treats irrefutable presumptions differently from other regulations or classifications. Thus, if an answer choice says invalid because it is an irrefutable presumption, it is probably wrong. You must consider whether it concerned a fundamental right or suspect or quasi-suspect class and judge it accordingly. Fair notice. A fundamental principle of our legal system is that laws that regulate people or entities must give fair notice of conduct that is forbidden or required. A regulation that fails to give fair notice violates the Due Process Clause. Equal protection. Constitutional source. The Equal Protection Clause of the 14th Amendment is limited to state action. However, grossly unreasonable discrimination by the federal government violates the Due Process Clause of the Fifth Amendment. For example, under the Fifth Amendment, the Supreme Court struck down a federal law defining marriage and spouse to exclude same-sex couples as applied to states that recognize same-sex marriages. Applicable standards. If a fundamental right or suspect classification is involved, the strict scrutiny standard is used to evaluate the regulation. If a quasi-suspect classification is involved, intermediate scrutiny is the applicable standard. If this classification does not affect a fundamental right or involve a suspect or quasi-suspect classification, the rational basis standard applies. So I apologize. We went directly from fair notice into equal protection. And that shift, right? We're naming all of the exact same constitutional clauses, right? 14th Amendment as the constitutional source and the applicable standards we've been going over here. So that is the same. But we're in subpart 18 here. And Part C, proving discriminatory classification. For strict or intermediate scrutiny to be applied, there must be intent on the part of the government to discriminate. Intent may be shown by a law that is discriminatory on its face, a discriminatory application of a facially neutral law, or a discriminatory motive behind the law. The third way to show intentional discrimination is the most difficult to prove. The discriminatory effect alone is not enough. The legislator's discriminatory motive must be shown, for example, in evidence of history of discrimination. So, in banking terms, number one is prima facie, or overt discrimination, and then disparate treatment and disparate impact. So there's only really three. And the part where we're saying the effect alone is not enough, that kind of relates to disparate impact. Whereas here, Romanet 1 through 3, discriminatory on its face, discriminatory application of a facially neutral law, and discriminatory motive behind the law. These are ors, or intent, ways to show intent, okay? So, intent is a requirement. When you're proving discriminatory classification. crazy that they can assume intent, right, by discriminatory application of a facially neutral law. But it's the application, right, that's in bold here, of a facially neutral law. So facially neutral law is one way, but let's just say everybody gets pulled over for speeding, then is released if they're white, and if they're not white, they're not released. Like, that would be a discriminatory application of enforcing speeding, for example, I think. It's a neutral face law, but in application, it's very, well, that almost is overt discrimination. But yeah, all three of those are examples of ways to show intent. So it's very different than how we apply banking compliance, fair lending analysis. So I'm looking at a chart now. It's got due process on the left and equal protection below. And there's all these lines pointing to the next column of boxes. And then the test, well, so the next column involves the rights or the classification of people that are limited to these rights, let's say, for example. And then the test is in the last column. So I'm not thinking, I'm just saying this. Due process is a regulation that affects everyone. So it's only two lines are going over to no fundamental rights being involved or fundamental rights being involved. If there's no fundamental rights involved, the rational basis test applies. We know the test is rationally related to a legitimate public government purpose, and the burden is on the challenger. If fundamental rights are involved, such as privacy, interstate travel, voting, First Amendment rights, which is your establishment clause, which is your free exercise, I believe, then strict scrutiny is applied, which is necessary to achieve a compelling government purpose. Burden is on the government. So like the bottom part of this table on the left defines equal protection. Regulation affects certain persons or classes of people, which is why it lines up to the three different classes for strict scrutiny, intermittent scrutiny, and rational basis test, which we know. And there's an extra line up to fundamental rights because strict scrutiny applies the same to suspect classifications such as race, national origin, sometimes alienage, as does it apply also to when fundamental rights are regulated. And so suspect classifications is part D in equal protection, and quasi-suspect classifications is part E, and other classifications is part F. And I would be surprised if something in here is new to me. So I'm reading it quickly. Classifications that are suspect if they are based on race, national origin, or alienage. Race and national origin. Classifications based on race or national origin are judged by a strict scrutiny standard. School integration. Only intentional segregation violates the Constitution. If school systems and attendance zones are established in a racially neutral manner, there is no violation. Thus, there is no violation if housing patterns result in racial imbalance in schools. Benign government discrimination or affirmative action. Government action, whether by federal, state, or local governmental bodies, that favors racial or ethnic minorities is subject to the same strict scrutiny standard as is government action discriminating against racial or ethnic minorities. Remedying past discrimination. The government has a compelling interest in remedying past discrimination against a racial or ethnic minority. The past discrimination must have been persistent and readily identifiable. A race-based plan cannot be used to remedy general past societal discrimination. So, this, way we just went there is legitimizing affirmative action. where there was no past discrimination. Even where a government has not engaged in past discrimination, it may have a compelling interest in affirmative action. However, the government action must be narrowly tailored to that test. And the only real application BARBRI is warning us that this occurs is diversity in public education. The Supreme Court has not found diversity itself to be a sufficient compelling reason to justify placing students in a particular elementary or secondary school on the basis of race. On the other hand, the court has deferred to public colleges and universities that have claimed that they have a compelling interest in having a diverse student body. However, the court will not defer to such institutions regarding whether a particular scheme for assuring diversity meets strict scrutiny. The school must show that no workable race-neutral alternatives would assure the diversity sought. And last, within this affirmative action section, states may eliminate race-based preferences. States are not required to have affirmative action programs for admission to their universities. Moreover, they may eliminate existing race-based preferences, including by voter initiative. Discriminatory legislative apportionment. Race can be considered in drawing up new voting districts, but it cannot be a predominant factor. If a plaintiff can show that a redistricting plan was drawn up predominantly on the basis of racial considerations, the plan will violate the Equal Protection Clause unless the government can show that the plan is narrowly tailored to serve a compelling state purpose, which is impossible. Alienage classification. It might have been made possible once in like the 60s, but it's essentially, they say when the government's burden is proving strict scrutiny, compelling interest or necessary to advance a compelling governmental interest, that they almost always cannot meet that burden. Alien classifications. This is interesting. Federal classifications. Because of Congress's plenary power over aliens, federal alienage classifications are not subject to strict scrutiny. Such classifications are valid if they are not arbitrary and unreasonable. State and local classifications. Generally, state-local laws on alienage are suspect classifications subject to strict scrutiny. Examples: it is unconstitutional for United States citizenship to be required for welfare, service jobs, or to become a lawyer. How about a driver's license in Utah? This is one that they wouldn't give to my friend who was a U.S. citizen. Without requiring additional documentation. Exception: participation in self-government process. If a law discriminates against alien participation in state government, for example, voting, jury service, elective office, the rational basis standard is applied. Also, the rational basis standard is used for state and local laws limiting certain non-elective offices involving important public policy, right? Because it requires some discretionary, deferring to the officer's discretion in, say, for instance, the example of police officers enforcing laws and probation officers, the same, and primary and secondary school teachers. They may be required to profess allegiance to our country's flag and be refused employment if they do not, because that's where we're inculcating our children. Undocumented aliens. Undocumented illegal aliens are not a suspect classification. That state laws regarding them are subject to a rational basis standard. However, denial of free public education to undocumented alien children is invalid, and more than a simple rational basis standard is used by the court. Quasi-suspect classifications. Thank you for finally making this distinction. It's been really hard to try to piece that out from the alienage classification, is that undocumented aliens are not subject to strict scrutiny standard. And you almost just need to see it particularly carved out to know that for sure. May they avail themselves of the court system? May they No, are they protected by the Constitution? I mean, love to know more because it gets hairy, especially in the application of criminal law. These immigration law is kind of probably where they end up, and it's its own separate track, and it's confusing, and there's not enough here to explain how that works. Quasi-suspect classifications based on legitimacy and gender are quasi-suspect. Gender classifications are reviewed under the intermediate scrutiny standard. They must be substantially related to an important government purpose. The government bears the burden of showing an exceedingly persuasive justification for the discrimination against, like, say, for instance, legitimacy and gender, which are quasi-suspect. So the standard substantially important related to important government purpose. Women. Intentional discrimination against women generally is invalid. Classifications benefiting women that are designed to remedy past discrimination generally are valid. And intentional discrimination against men. Intentional discrimination against men is generally invalid. However, certain laws have been found to be substantially related to important government interests, such as statutory rape laws and all-male draft. Exam tip. The following chart spells out the most likely exam question topics. In any event, remember that most gender classifications are struck down. This is particularly true if they perpetuate stereotypes of economically dependent women. Here's the classification and the status, just to extend that last sentence further. The classification of gender-based death benefits are invalid. Gender-based peremptory strikes are invalid. Alimony for women only are invalid. State-supported all-male or all-female schools are invalidated. Discriminatory minimum drinking age is invalid. Discriminatory statutory rape laws is valid. All-male draft is valid. And requiring American fathers but not mothers to prove their parentage of non-marital children born abroad in order to obtain U.S. citizenship for them is valid. Legitimacy classifications are also viewed under the intermediate strict scrutiny standard. They must be substantially related to an important government interest. Discriminatory regulations intended to punish non-marital children, for example, a law providing a benefit to marital children but not to non-marital children, are invalid. Example, a law allowing only marital children to recover from their father's estate is invalid. But note, a law allowing non-marital children to recover from their father's estates only if parenthood is established before a father's death is valid. F, other classifications. All other classifications are evaluated under the rational basis standard. These include age, disability, and wealth classifications. For example, mandatory retirement ages may be established. And because education is not a fundamental right, there is no denial of equal protection when wealthier children can afford to pay for access to the best state-operated schools. Exam tip. For the MBE, you must memorize the suspect classifications: race, national origin, sometimes alienage, quasi-suspect classifications, gender and legitimacy, and the fundamental rights. To interstate travel, privacy, voting, First Amendment, and other classification or any other right is not entitled to any more than the rational basis test, and thus the government regulation will usually be valid. Don't let your personal feelings lead you to apply the wrong standard and pick the wrong answer because you think the right is important to the group or the group is worthy. All right. Fundamental rights. Page 40. Intro. Certain fundamental rights are protected by the Constitution. If they are denied to everyone, it is a substantive due process problem. If they are denied to some individuals but not others, it is an equal protection problem. The applicable standard in either case is strict scrutiny. Thus, government action must be necessary to protect a compelling governmental interest. Remember that there must be no less restrictive means to achieve the goal. Right of privacy. Various privacy rights, including marriage, procreation, conception, and child rearing, are fundamental rights. Regulations affecting these rights are reviewed under the strict scrutiny standard. Marriage. A law prohibiting a class of adults from marrying is likely to be invalidated unless the government can demonstrate that the law is narrowly tailored to promote a compelling or overriding or at least important interest. Importantly, the fundamental liberties guaranteed by the 14th Amendment require every state to issue marriage licenses to two people of the same sex and recognize same-sex marriages performed elsewhere. However, a statute restricting the rights of prison inmates to marry will be upheld if reasonably related to legitimate penological interests. Use of contraceptives. A state cannot prohibit distribution of non-medical contraceptives to adults. Procreation. Individuals have a fundamental right to reproduce. It cannot be limited by the state. Abortion. The right of privacy includes the right of women to have an abortion without interference from the state under certain circumstances. However, normal strict scrutiny analysis cannot be applied because the state has two compelling interests here that often compete: protecting the women's health and protecting the fetus that may become a child. In the latest abortion rights approach, the Supreme Court has adopted two basic rules: the pre-viability rule and the post-viability rule. During pre-viability, no undue burdens can be imposed by the state. Before viability, which is a realistic possibility that the fetus could survive outside the womb, a state may adopt a regulation protecting the mother's health and the life of the fetus if the regulation does not place an undue burden on or substantial obstacle to the woman's right to obtain an abortion. Post-viability rule may prohibit abortion unless women's health threatens. Once the fetus is viable, the state's interest in the fetus's life can override the woman's right to obtain an abortion, but the state cannot prohibit the woman from obtaining an abortion if it is necessary to protect the woman's health or safety. Right, so the government can finally override an evil woman at post-viability. Continue. There's a table here. I'm not going into it. You know why? Okay, yeah, I am. It defines undue burden and burden. The reason I didn't want to go into it is because I felt pretty certain that this will probably not be tested because of how big of an issue this has been recently. Will really confuse everyone, I think, because we're not responsible for knowing the new information, but for the people who do, I don't like. I wouldn't know how to answer based on the new information, and the people who know the new, Supreme Court upholding Texas's greater burdens on abortion would thus not know the old standard. So I don't think this will be tested in an essay. No undue burden means that requiring doctor to give women relevant information to make informed consent, requiring 24-hour waiting periods, requiring parental consent or parental notice in order for minors to obtain an abortion if there is a judicial bypass option, requiring that abortions be performed only by licensed physicians, and barring a well-defined partial birth abortion procedure when other abortion methods are available. Those all do not create an undue burden on the woman's, quote, right to murder their kin. What does create a burden is requiring a woman to notify their spouse about the abortion, because we're assuming that their spouse is an evil man. And requiring physicians to perform abortions to have admitting privileges at a nearby hospital is an undue burden. So what they really mean to say is that initially Texas had this statute that limited the places that could perform an abortion, right? And they're saying it's for safety reasons, but really it's so few locations that in order to proceed with an abortion, that aborting mother would need to pretty much stay in a hotel, in very many relevant areas where an abortion might be sought, or where a person seeking an abortion would have to travel to get one done. So that would just be, that's why they're calling it a burden, is because they're talking over 50 miles to get to the admitting hospital where abortions can be performed. I think that's what they're trying to get at. And this is not a recent case either. That's just I don't think it was upheld. So Texas may have then went after it again in another way and actually won. And I think that's probably the sense of the newer regulation, but I don't entirely know. The definition of burden, like, or what's not a burden, the way where we get this from, honestly, is a Pennsylvania case. Thanks, Pennsylvania, for carving the way. Casey versus like what the Planned Parenthood, where they're like, requiring informed consent, a 24-hour waiting period, sometimes parental consent or parental notice, unless, judicial bypass because that person just knows what's best for them at their weak age of 17. Licensed physicians, obviously requiring that is not an undue burden. And here's barring a well-defined partial birth abortion procedure when other abortion methods are available. Okay. Yeah, so this partial birth abortion procedure, I read about it in my constitutional law book, and it is such a horrific and disgusting procedure that they're only naming it here by, they're only giving the name of it here and saying that when other abortion methods are available, that it is not an undue burden to ask an aborting mother to use another method that is available over the partial birth abortion procedure. And I'm not going to describe what that includes, but it is obscene. I'm going to read Remedy. Did I read Remedy? And financing abortions. So the government has no obligation to pay for abortions, and also has I don't think they're required to provide contraceptives either. Now they may, and when they do, they can do it however they want because it's not a right. It's like a government benefit which can be administered the way that the government chooses and feels they would like to. So this comes up in MBE questions like constantly. I'm surprised there's no exam tips here. Remedy. When a court is faced with a statute restricting access to abortions that may be applied in an unconstitutional manner so as to harm the mother's health, it should not invalidate the statute in its entirety if the statute has valid applications. Instead, the court should attempt to fashion narrower declaratory and injunctive relief against that unconstitutional application. One thing I want to add here is I really thought for sure that they were going to say something about standing, because abortion is the kind of thing that since gestation is like 9 months, if your constitutional law case isn't being heard in 9 months, and this is what Roe v. Wade stood for, if I remember correctly. Roe v. Wade is really about the fact that by the time you are in court, you've lost standing because there's no more controversy. There's no more remedy available, like, because you've already given birth. And so they fashioned this new exception to standing, which is capable of reoccurring but evading review. And that's how Roe v. Wade was able to even make it into Supreme Court. I mean, Wade had her baby already, but she was capable of becoming pregnant again, and her legal question wasn't addressed yet, or legal right assertion was not asserted, and she wants to reserve that for perhaps, a point in time when she's pregnant again and wants an abortion after whatever the post-viability period. And that's what it's stood for. And I would love to know what Wade's, daughter or son is doing and what that familial relationship's like, because I would love to hear from Wade that she not aborting her child is the best decision she ever made. That's something that I'd love to see on Oprah. I asked Oprah to do that. Thank you, Oprah, for not doing that because no one cares. Obscene reading material. The right to privacy includes freedom to read obscene material in one's own home, except for child pornography. But not the right to sell, purchase, or transport such material. Rights of parents. Parental rights are fundamental rights. They include the companionship, care, custody, and school, or to forbid visitation with grandparents. Keeping extended family together. We're talking about fundamental rights here. Zoning regulations that prevent family members, even extended ones, from living together are invalid. However, this right does not extend to unrelated people. These zoning regulations are usually meant for like group homes, but sometimes they be like 5 unrelated people can't live together. Well, if they're extended family members are not part of that, so that's why most of the zoning laws say unrelated people. Intimate sexual conduct. The state has no legitimate interest in making it a crime for fully consenting adults to engage in private, intimate sexual conduct, for example, sodomy, that is not commercial in nature. While the court has not stated what standard of review would be applied to such laws, it has indicated they cannot even pass the rational basis test because of the lack of government state interest. Collection and distribution of personal data, no privacy right. So just another exception to when it's commercial in nature, right? Suddenly laws around intimate sexual conduct are valid, right? If the sexual conduct is commercial in nature. The other thing is if it's like highly violent, and that was a fun case to read. Because there's some forms of battery that can't be consented to. I'll leave it at that. Collection and distribution of personal data, no privacy rights. The state may reasonably gather and distribute information about its citizens. Thus, there is no privacy right to prohibit the accumulation of names and addresses of patients for whom dangerous drugs are prescribed. No privacy right to prohibit the accumulation of names and addresses of patients for whom dangerous drugs are prescribed. So that's like an exception to the privacy rights that they didn't even talk about in the first place. Which, like, they tell us not to skip things. Like, what's the privacy right? What is the right to privacy? Before you start telling me that the collection and distribution of personal data is an exception to it. So the state may reasonably gather and distribute information about its citizens. That's so ridiculous. Usually marriage falls into the right of privacy. Anyway, right to vote. Yeah, what is privacy? What are the privacy rights? All I've seen here is that there aren't any. What are the rights to privacy that are respected? Examples. Sometimes it's like medical information. Because like here, you just have to reasonably gather and distribute, which means if you are doing like a crazy study, you got to anonymize it. And that's about all I got for examples. Right to vote. The right to vote is a fundamental right, unless restrictions on that right, other than on the basis of residence, age, and citizenship, are invalid unless they can pass strict scrutiny. Restrictions on right to vote, residency requirements, reasonable time periods for residency, for example, 30 days, are valid. Note that Congress may override state residency requirements in presidential elections and substitute its own. Identification. A state may require voters to show a government-issued voter ID. Property ownership. Conditioning the right to vote or hold office on ownership of property is usually invalid. Exceptions. Special purpose elections, for example, water storage districts. Poll taxes are unconstitutional. Primary elections. States may require early registration to vote in primaries. However, states cannot prohibit political parties from opening their primary elections to anyone, whether or not registered with the party. Huh. Another thing is, they're not they're not giving it here, but like a litmus test. No litmus test. And they just are like, I don't believe the litmus test. I would be unconstitutional, just like the poll taxes are. But it's not here. I don't know why it's not here. Don't these people know everything? Dilution of right to vote. One person, one vote principle. The one person, one vote principle applies whether any level of government, state or local, decides to select representatives to a governmental body by popular election from individual districts. Congressional elections. States must use almost exact mathematical equality when creating congressional districts within that state. This is not true of Congress. However, when it apportions representatives among the states, Congress's good faith method for apportioning representatives commands more deference and is not subject to a precise mathematical formula as are state plans. Was that about gerrymandering? I don't even care. State and local elections. For state and local elections, the variance in the number of persons included within districts. Oh, one person, one vote principle. Basically, that comes from the Constitution, where they were saying, like, based on your race, like, you will either get one vote or like 8-1 vote, or 1-8, 1 out of 8 people vote, like something like that in the Constitution. That got like explicitly invalidated. But that's what this principle basically derives from. They just don't want to re-say it here. They don't want to act like they actually had that position in the United States history at one point in time. Gerrymandering comes after all of these parts under the one person, one vote principle. But I still have a couple more left, right? So for state and local elections, the variance in the number of persons included within the districts must not be more than a few percentage points. So this is how, like, a city of like a bunch of lower income individuals, often of diverse populations, can be super small districts, whereas like rural outlying areas can be huge because they're trying to get a low variance in the number of persons included within the district, not by more than a few percentage points, but in effect, it tends to change. The districting tends to be along party lines, and that gets tricky to cut those lines in a constitutional way. What I really want to know, which I probably won't know by reading this, is what is the jurisdiction for hearing arguments about districting. And I do believe it's different for federal elections and presidential elections and state and local elections. Districts can be measured using total population. States need not measure the equality of their districts by counting only persons eligible to vote. It is sufficient to count the total population. This best serves the one person, one vote principle. So you're talking like a district that has like a prison in it. Those people can't vote. Whatever. Exception. Appointed officials and officials elected at large. The apportionment requirement is inapplicable to officials who are appointed or elected at large. Exception. Special purpose election. The one person, one vote principle does not apply to elections of officials who do not exercise normal governmental authority, but rather deal with matters of special interest in the community, such as your water storage district's case again. Now, gerrymandering is outside, is within the dilution of the right to vote, but it's not part of this one person, one vote principle. So race and presumably other suspect classifications cannot be the predominant factor in drawing boundaries of voting districts unless the district plan can pass muster under strict scrutiny. Very difficult to do that. And it doesn't say if this is, doesn't say if it's state or local elections or federal presidential elections. So we're going to assume both since it makes no distinctions. States may use independent commissions to draw districts. To avoid gerrymandering, states may use independent commissions to adopt congressional districts rather than allowing a state legislator to redistrict. So that helps. Candidates and campaigns. Candidate qualifications. Fee must not preclude indigence, and restrictions on ability to be a candidate. So states may not charge candidates a fee that results in making it impossible for indigents to run for office. A ballot access regulation must be reasonable, non-discriminatory means of promoting important state interests. A state may require candidates to show reasonable support to have their names placed on the ballot. I think there's a recent case about how, like, it wasn't proper to, I can't even go into it. Get rid of note card on it, though. Campaign funding. The government may allocate more public funds to the two major parties than to minor parties for political campaigns. Right to travel. Okay, we're almost at part 5, and we will take a break. Interstate travel. An individual has a fundamental right to migrate from state to state and to be treated equally after moving into the new state. That's like the very best definition. You must use that in essays. However, not every restriction on the right to cross state lines is an impairment of the right to travel. For example, increased penalties for the father abandoning his children and leaving the state are valid. A problem arises when a state imposes a minimum durational residency requirement for receiving its benefits or otherwise dispenses state benefits based on the length of time a person has resided in the state. It is not clear whether the court always reviews these regulations under the strict scrutiny standard. It may be best to just recall the following examples. Residency requirement and status. So a 1-year residency to receive full welfare benefits is invalid. A 1-year residency to receive state subsidized medical care is invalid. A 1-year residency to vote in state is invalid. But a 30-day residency to vote in the state is valid, and a 1-year residency to get divorced is valid. So again, about interstate travel, probably the best definition I've ever seen for this is that an individual has a fundamental right to migrate from state to state and to be treated equally after moving into a new state. International travel, however, is not a fundamental right. It is, however, protected by arbitrary federal interference by the Fifth Amendment due process clause. The rational basis standard applies. Part 5 will involve First Amendment freedoms. And do we ever get to part 6? I'm assuming part 6 is freedom of religion. Oh, no. You know what? That's under the First Amendment. So part 5 may be the last part. It's like 15 pages long. And I just read 11 pages. So it tells you it'll probably be about a little over an hour to get this done.